and hearty welcome to all the participants and the learned speaker to 93rd webinar on company securities and insolvency law, recap of recent regulatory and legal updates. This we are organizing as a part of knowledge sharing initiative by corporate professionals. Friends, as you are aware that we are organizing every Friday webinar of topical interest. Then we got some suggestions and accordingly we decided that let's keep first Friday of every month for recap of the recent regulatory updates since last 1 month. So accordingly, we have identified 3 topics: company law, securities law, insolvency, and other updates. So whatever new law, whatever new circular, whatever new changes, whatever new updates, any important case law which are coming during the last month, we are discussing. And our discussion process is also divided into 4 parts. Vivek, can you show me the last slide? So first, recap of all the regulatory and legal updates during the last month. Update in company law, security law, IBC, FEMA, and other economic law. Now, these are the laws which we are covering, but the most important thing is first we are explaining what is this change. Then we are discussing about the impact of these regulatory changes. And then next is implementation or interpretation issue, if any, when we are reading and studying. And then we have a question answer session relating to these updates. So friends, in case in a month you have not because of some reason you have missed out any circular, any other thing, with assurance you can join this webinar of first Friday of every month. An entire month's updation will be there. Today we are covering the updation which has come yesterday also. So everything which is there in last month we want to cover. So you can do it. And next is we have one monthly newsletter that is called CP Connect, and that is also covering all these things. And that we will mail to all participants today itself. So you can read that also, and on YouTube you can see that webinar, or you can go to our website and you can recap whatever discussion has taken place. The object is very simple. Sometime what is happening, law has come and then we have started implementing, or we are interpreting in our own thing. So we have called the experts, those who will threadbare discuss, and then they will come out the interpretation and point of view. And sometime what is happening when the expert discuss, there are 2-3 meanings and 2-3 interpretations are coming. So that interpretation we can understand that if anything which has come for simplification or clarification and it has a multiple meaning, it means it requires more clarification. So by the end of this program, we will summarize all the questions like this, that these are the questions where there is a need of clarity. We'll pass on to the respective regulator and they will either bring out the FAQ, circular, or some clarification by their various notes. So this is the object of this program, and this will be continue in future. So log on first Friday of every month for updation. Friends, today we have a galaxy of speakers. We have Mr. Amit Gupta with us. Amit Gupta, because in our program, he has attended so many, so I'm not reading any biodata. Amit Gupta is there. Then we have Anjali Agrawal. Then we have Ankit Singhi. He's a head corporate affairs and compliance corporate professional. Then we have Manoj Kumar, partner and head M&A transaction. Then we have Ravi Prakash, who is associate partner, corporate professional. Now, Ankit Singhi, Ravi, and Manoj and Amit Gupta will make a presentation on recap of regulatory and legal updates in company securities and insolvency law. And then all these panelists will talk about the issue and its implication and impact. And then I will request all the participants to post their query in the chat box. And then after this, we will take up the questions one by one. Now, first, I will request Ankit to take up the matter on company law. Then Ravi will take on securities law. Then Manoj and Amit will take up on insolvency law. Over to you, Ankit.
Thank you, sir. Good afternoon to everyone. So, sir has already outlined the objective of this webinar. So without taking any time, I'll just start with the recap of regulatory changes and updates during last month, starting with corporate law. So during last month, government launched a portal on CSR, which is called National CSR Exchange Portal. And I think this was a portal which was in need for a long time, since a lot of companies find difficult to identify suitable CSR projects. So this portal is actually a kind of a matchmaking platform where both the corporates and implementing agencies can connect with each other and work together on various CSR projects. So if there is a corporate who is looking for some CSR projects, he can log in, register himself, and then find suitable CSR projects. And implementing agencies too, who have already registered with the ministry by filing CSR1, and they can also log in, create their own projects where they can highlight the work that will be done under that project. And companies can find out those project basis the search on the portal, or the implementing agencies can also reach out to the concerned corporates. So I think this was a much needed portal specifically for companies where at times the CSR expenditure is meager and they find it difficult to identify suitable CSR projects. If implemented properly and used properly by both the corporates and implementing agencies, I think this will serve a very large purpose of helping both the corporate and the social sector in meeting their objectives. So as mentioned, we can use this portal to identify suitable implementing agencies, select suitable CSR projects. Even there is a management based ERP system available on the portal, through which you can manage all the CSR projects which you have chosen on the website through the portal. And so it serves a wide range of purposes. Along with the web portal also provides a lot of information in terms of, it has a great amount of FAQs on the CSR, most of them which are already issued by ministry in by way of various circulars. Those are already there. Then the huge data is also there in terms of various data points like companies who are doing CSR areas, and specific districts where CSR projects are being done, specific areas under Schedule 7 where CSR activities are done. So all the data that is being captured by MCA through various filing, one can also find a lot of details on that data in the portal itself. So I believe it will definitely help both the corporates and implementing agencies in carrying out their CSR obligations. Moving forward, there was a recent change in the process of strike off. Earlier, when we filed for strike off, as per the provisions of removal of name of companies from register of companies rule, at the time of strike off, in case there is any resubmission is required, there was only one resubmission that was allowed under the rules. But now, in order to ease the process, two resubmissions are allowed as per the amended rule. So registrar can allow you to resubmit any document in case there are any defects, or if there is any pendency or other incompleteness in the originally submitted documents. Then you can request the registrar to allow a resubmission for 2 times, which was earlier allowed only for 1 time. Then this was another important topic which was debated a lot, that there was a requirement of any person who registers with the independent directors database and is required to undergo the online proficiency test, means he is not eligible for the exemptions granted. Within 2 years, that person has to undergo that test. I think last year the deadline of 2 year ended for lot many independent directors who have registered with the database, and a lot many of them has failed to qualify by the online proficiency test. So once the online proficiency test you were not able to qualify, your name was automatically deregistered from the independent data bank database. And currently, before this amendment, there was no facility for you to re-register. If you have already registered, you failed to qualify the exam, the system will not allow you to re-register again. So now they have made a further provision by way of amendment in the rules, where you will be allowed to re-register for a further period of 1 year on a payment of special fee of rupees 1000. And if you are able to pass the test between that period, then your name will be considered as included in the general category of where every other category of registered independent director is available. And till then, you will be shown as a separate category, which is called as a restored category. I think we can have a little discussion with other participants, because there was a lot of confusion as to whether if someone fails to qualify the exam, one repercussion is that in terms of the declaration that the board has to submit as a part of the director's report with respect to the efficiency expertise of directors, where independent directors, where online proficiency test was one of the criteria. And another is that another question that also arose from the failure to qualify is that whether one has to vacate the position as an independent director in any company. And since the fact that once you fail to qualify the test in the original period of 2 years, your name is automatically deregistered. So registration of independent director, which is also one of the specific requirements for acting as a independent director, that also get negates by way of deregistration. So you are no more registered as part of the ID data bank, and you are not then fulfilling the requirement of the rules, which requires every independent director to be part of the registered database. So, so there are two consequences. First is with respect to the disclosure in the director's report, and two consequences arising out of deregistration and failure to take the test. So, if Amit, you have any view or?
Ankit, I believe there are a couple of issues surrounding this particular subject. One issue which is not very clear, because we'll take up the previous amendment also, which facilitated the registration in the database by payment of the additional fees of 1000 rupees. The similar provision came for that also. Now, if we go in a backdrop, the backdrop was that in December 2019, this requirement was inserted by way of necessary changes in the rules. And the law provided that within the period of 3 months, the existing persons who were a director in any company will be required to register themselves in the director's database. That was a requirement number one. Requirement number two was any person who proposed himself to be appointed as an independent director on or after commencement of these regulations, these rules, he was supposed to register himself in the director database and pass the proficiency exam within, originally the period was 1 year, later on it was extended to 2 years.
2 years.
Now, this requirement of, there were two categories of people, one who were already in the directors category. For them, the timeline was 3 months. Those who proposed themselves to be appointed as a director, there was no timeline. They have to register prior to getting themselves as appointed as an independent director. As far as first category of persons were concerned, this timeline kept on increasing because we know COVID was there, and 31st of December 2020, this timeline was extended. And even afterward also, as I understand by reading the amendment what came in the previous year, this category of persons were allowed to register even after expiry of 31st of December 2020 by payment of additional fees. Now, I have a question. Let us say some company has appointed an independent director without having his name registered in a database. Whether this category of person was also covered by the amendment what came in 2021 by payment of additional fees, whether he can seek registration and regularize his default or not. That is the question number one. I'll just flag. Now, number 2 point, what you have flagged the government, why government has to come out with the kind of relaxation for the passing of proficiency examination, because in database, I'm sure that government has done some statistical analysis. There is still a large number of independent director category who have still not passed the examination, though there was a large number of independent director category who is already exempted by virtue of the relaxation. As we know, originally this law was very stringent. The relaxation or exemption from the proficiency test was available only to very few select class of people. Previous year, we know the government has relaxed, and by and large, if you have a 3 years of experience, you are allowed to be exempted from the proficiency test. But still, government has noticed that there is a large number of independent director who has still not passed. So a window is required to be given so that their term does not come to automatic cessation, leading to a situation of chaos for many of the corporate houses. That is what my understanding is. A welcome move, certainly, giving additional time to these independent directors to allow. Now, question what perhaps Ankit wanted to understand is, one, let's say the person who has failed the examination during this period of 2 years, whether he is also eligible to get his name restored. To me, I don't think that government intended to do any distinction between the one who has given exam and failed or one who has not attempted and not given the exam.
Yeah, both same category.
Both are in the same category and both will be entitled to be restored in the independent director database as long as he is able to pass the examination in next 1 year time. I don't think that there would be any issue. Now I have a
So it means automatically a year's extension in terms of the test has been given.
Yes, in a way, government has given that 1 year extension window. Now, as we know, the criteria of exemption is 3 years. Experience, 2 year already passed, 1 year now relaxation given. So anybody, even if he disqualifies after 3 years, will he be qualified to claim the exemption of proficiency test? Is a doubt that I am having. I'm asking a question to myself, but I'm not very sure. Is the government trying to give a window this way to regularize all the directorship? I am not having any view on that. I'll request the other, maybe Manoj or Anjali, maybe in a position to throw some more light on that.
I think this is certainly an issue to look into. We'll red flag also this to MCA to get some clarification.
No, I think Ankit, the government has intentionally
Might be
provided. The intention is not, because by bringing out the independent director database, their purpose by and large has served, because the dummy directors, the dummy independent directors, by and large have been weeded out from the system. Because a lot of informations and a lot of other things are required to be updated on the directors database. So my personal experience goes that by and large the purpose has also been served. So even if government is thinking, there is nothing wrong in doing that.
Yes, I also agree to this. There is no need of this proficiency test kind of thing. The company's law has already provided for upgradation requirement for the companies. It is the company's obligation to inform the independent directors about the changes and all that. So that is sufficient compliance. And if the KYC is happening and database is being maintained, that should be sufficient. Proficiency test may not be making much difference.
Holistic view is not taken, and because you have opened a institution, and that institution has to do some work, so they are thinking to do something,
yes,
maybe not effective, which may be harmful. Okay, So I think the ministry should take a holistic view. Ankit, proficiency test is mandatory for executive director, MD, or any other nominee?
No, only for independent directors.
Okay. So, and nominee director?
Nominees are not independent directors.
They will not be. If
Yeah.
you want to be independent, then you have to pass their exam. Okay.
Yeah. So moving ahead,
It's just
so
one last issue
yeah.
I think that you flagged. We could not discuss that.
Mm.
As to it is whose default. Let us say somebody was there who represented himself that he is a independent director and he qualifies to all the condition and his name is there in the database. Later on, when the company detected, company found that his name is not there in the database or his name has been removed. Whether it is a default of a company or is there any way by which this default can be rectified? What is the solution to that? I think a couple of companies are struggling with such type of situation also. Maybe director has misrepresented or has not represented properly, or the company has not done due diligence at the time of appointment.
I think the case can only be of due diligence, or in some case, for example, you have taken a limited membership and during the course of the time of 5 years, you have not failed to renew yourself. And that aspect is not known to the company to that extent that your name is no more there in the database because you have failed to get yourself renewed. So to that extent, some kind of diligence company has to undertake. But ultimately, the responsibility of getting yourself registered is with the independent director. But yes, company has to make sure both. First, at the time of appointment, it has to definitely make sure that the director is registered with the independent director, and vigilant companies can also, to some extent, in case their registration is not on a lifetime basis, then shall keep a watch if the renewal is due during their course of tenure.
So question is from the compounding of offense perspective, whether company can, whether the company is liable for any default, whether it is a default of a company or not. Because if we go with a plain vanilla language of the act, it says it is a default of a director.
It should be. I think why will company will be punished for this?
Company is not liable. So whether a company wants to regularize, what is the option available, as we were discussing in the first instance, whether the additional fees option is available in such cases also or not, whether if he is restored, whether his name is there in the database today, whether he'll be considered as in the database 1 year prior also, and whether this will be making the default good or not is a question.
Then there can be many questions. For example, a director submits a forged passing certificate. Company relies on the same, submits a declaration in the board report. Then later on, it was found that it was forged. So one can say directors have not exercised diligence. They have relied on a forged document. So disclosure is also wrong. So there may be a lot of complications arising out of it. But I think initially the burden should only be on the directors. Yeah, companies should exercise some extent of diligence to ensure the compliance.
All right, I think we can
yeah, so moving forward, another important change, while it's a little surprising change, because while most of the places under Companies Act where there were fines provided as a penal mechanism, the government resorted to change that to penalties and move to an in-house adjudication mechanism. This is for the first time where a penal mechanism has been reversed to the compounding mechanism, where the penalty amount has been changed with only fine. And now, since it is a fine, any non-compliance of NFRA provisions will trigger non-default default will require undertaking of compounding in order to get out of it, unless and until you want to fight it out in the court. So the method of redressal is compounding, which was otherwise in-house mechanism. And as an experience, I feel compounding is much better than in-house adjudication mechanism. Still, a lot of things you can play with the amount of default under the penalty. The amounts are fixed. A lot of ROCs are not very comfortable in exercising a lot of discretion in terms of putting the penalty amount. So fine is still much more convenient as opposed to penalty. And I don't know the objective behind reversing it back might be the same to give a more comfortable method of getting it sorted.
No, I think Ankit, I had been always voicing against the decriminalization drive what the government has been doing for quite some time. On one hand, it has been much appreciated that government is very sensitive to the corporations, that they don't consider these minor offenses as economic offenses as a serious one, and they wanted the adjudication proceeding, and they don't want to tag the promoters with the criminal offense category, criminal victim. But the real intention, what we have understood is, because government does not has the machinery to prosecute the n number of companies. There are 14 lakh odd companies if you consider 3 directors on an average also. So you can just imagine if the prosecution has to be launched against the defaulters, and if they show the statistics, roughly 6.5 lakh companies are only compliant with regard to the filing of balance sheet and the annual return. Remaining companies are prima facie on the default even of the basic document, that is of balance sheet and annual return. So if for rest of 8 lakh companies the ministry has to go for prosecution, you can understand how much burden government is going to create on the machinery. So criminal trial was impossible, because criminal trial was to take place before the special court in terms of the provisions of section 435. Now, what government smartly did, they decriminalized the majority of the offenses so that the adjudication proceedings can be initiated. Now, adjudication proceedings are to take place before the adjudicating authority, who is none other than the registrar of companies of the respective state. Now, registrar has all the wherewithal, definitely his office infrastructure and numbers also all across the country are sufficient to handle the civil adjudication mechanism, whatever has been referred to. On the contrary, when this provision of NAFRA was originally kept as civil offense, government realized that in case of these offenses, without doing a trial, you cannot perhaps conclude the proceedings, because a criminal trial is necessary to establish the offense in these cases. So they have with that objective, perhaps government has decided to put it again back into the criminal offense category, so that the proper complaint can be launched before the special court, respective jurisdiction, and proper trial can take place, and after that the person can be punished. But good part is that, as we understood, the advantage of criminal offense was that very selective cases go for criminal trial. Those who are not very serious in nature perhaps can always go for making the offense good and go for compounding as well, as Ankit was saying, the luxury which is not available in case of adjudication. So I feel that is the intention behind.
So continuing further, the timelines for submitting Form 11 in case of LLP is extended. Again, earlier it was extended from 30th May to 30th June. Now it extended to 15th July. I think we all know it's because of technical difficulties under the newly launched version for undertaking LLP filings. And I believe, considering the current stage of status of the portal, this may further be extended to further additional dates till the time the situation is normalized fully.
Ankit, the biggest problem what the professionals are facing in this regard, perhaps corporate are not having much difficulty, because they have prepared their financials of limited liability partnership and they have submitted it to the professional. Now, professional life is becoming difficult and miserable, because there is no notification on the MCA portal that the portal is not working. MCA portal does not recognize that there is any problem in the portal. And MCA portal, on the contrary, is consistently showing the data which says that these number of forms have been filed since 1st April 2022. So Now, when corporate reaches out to the professional with regard to the status, so professional is not able to respond or has to take the excuse that portal is not working. On the contrary, portal is saying that these number of forms have been uploaded. Now there comes a difficulty for the professional. So my only request is that either through the institutional platform or through Chamber of Commerce, the representation should be made to the government, at least to take a cognizance of this fact. I'm not saying that problem is not there. Definitely genuine problem is there. There is a rollover of one service provider to the other service provider, and there may be some teething problem. So these problems are inevitable. Any technology can have. Last year also the income tax department portal was having bad experiences from June to September. But at least the good sign was that the government came forward to recognize that yes, there is a problem. Now, in contrary, in LLP portal, nobody is coming forward to recognize that yes, there is a problem.
They are recognizing indirectly by extending dates.
That's all right, but
let's hope the system will resume normalcy soon. So moving ahead with securities law, I'll take one small amendment and then Ravi will take it further. So I believe yesterday SEBI issued a circular whereby they have amended the certain portion of the shareholding pattern that needs to be filed. And two annexures are provided in this circular. One with respect to public shareholding and other is with respect to FDI limit. So with respect to the public shareholding, major takeaways with respect to the change of format is now in the shareholding pattern, direct shareholding of directors other than independent directors, KMPs, relatives or promoters which are not immediate relatives, and all trusts where the beneficiaries or the trustee are promoter or promoter group will needs to be separately disclosed as a in the shareholding pattern. Another important change is that names of all financial institutions, institutional investors, mutual funds, insurance, venture funds, all these names also needs to be disclosed as per the revised format. An important thing which they have added as a category, that while reporting the shareholding of public shareholders, three category of the shareholding has to be classified in three categories wherever applicable. First is with respect to shareholders who are holding shares and having any right to nominate a director on the board of the listed entity. If any public shareholder has such right, it has to be disclosed in the shareholding pattern by selecting the relevant category. Then the second category is with respect to the promoters, person acting in concert with the promoters wherever available. That is the second, that is another category. And I just forgot what's the third category. I'll not able, just a second. There is another category that is added with respect to promoters only. So all these categories one need to classify in case of applicability in any of the three categories in the shareholding pattern. So these are the key changes with respect to the shareholding pattern that needs to be provided. Among there is also a small annexure they've added with respect to FDI limits. And there is a case of board approved limits and current limits. So board approved limits, generally there are no board approved limits in any company which have FDI under automatic route is allowed up to 100%. And there was a case earlier when for FPIs or NRIs there were certain limits provided under the rules, and there was a sectoral cap. And if there was a sectoral cap, the shareholders board can always recommend to the shareholders to increase that limit to the sectoral cap by passing a special resolution. On that also, I think a couple of years back, all the limits were raised to sectoral cap automatically, unless the shareholders have decided in the general meeting otherwise that the sectoral cap and the current limits need not to be extended to the sectoral cap. So in case a board approved limits in all the cases would be the approved limits of FDI under the FDI policy in case up to the limit which is allowed under the rules itself. So these are the two specific categories of disclosures that are added as part of the revised shareholding pattern, and it will be applicable from the quarter ending 30th September 2022. So for this quarter ending June 30th 2022, the existing shareholding pattern will be filed, and for the 30th September 22 quarter, the new shareholding pattern and thereon will be filed as per the new format.
Okay. This particular thing which has come out.
Yes, sir.
Okay. Can you, anybody can explain that what are the problems normally that I was
I'll
facing?
flag one issue, sir, which I think we have been discussing in this forum also quite some time. If we recall, in the previous year, 2021, from September 2021 quarter itself, the promoter details were required to be bifurcated into promoter
and promoter group.
Right. Thereafter, we know the legacy of listed entities in India has been quite long, quite old. Now, from 70s, 80s, the companies have been listed. So, roughly 4 to 5 decades, the companies have spent out, and over the period of time, the law has also evolved and amended. Many of the companies have been having a challenge, especially in the last 1 year, to rightly classify their promoter and promoter group, because many of the companies were not having a correct mapping of the promoter group, because whatsoever was appearing in their promoter or promoter group, as far as prior to 30th September 2021 was concerned, they just continued that without remapping whether anybody was covered therein or not. Now, as this amendment is saying that for the public shareholder category also, you have to give a bifurcation with regard to the associate, subsidiary, director, relative, and so people. I'm just thinking aloud, perhaps there may be a couple of entities which may qualify as a promoter group. Is the intention to dig out those corporate and ask the companies to club these details into their promoter group category? Or what could be the other intention of putting these classifications into, or identification of these category of people also in the shareholding pattern? That is one point which comes to my mind by reading these amendments.
Another important point with respect to person acting in concert, it says information with respect to person acting in concert if available with the company. So the onus is also whether it's on the promoters or it's on the person acting in concert to disclose that fact that they are acting in concert, and whether such disclosure, Manoj, will have any impact with respect to the SAS regulations.
Actually, though, that two regulations are separate. One is LODR and one is takeover regulation. Yes, person acting in concert is a concept which is for any specific transaction and not in general. So a person may be acting in concert for particular transaction, but he may not be connected otherwise. So it may be totally unrelated competitive business houses who can come together to buy some company, right? So it is a transaction specific terminology which is used in takeover regulations. Now, if we are saying under this law regulation, this shareholding pattern, if it is disclosed, what is the intent? Whether that person will continue to be person acting in concert for all time to come, or what is the basis on which company will categorize a person as a person acting in concert? Till the time it is deemed person acting in concert, like immediate relatives of a person or a company which is controlled by the same person, then obviously they may be falling under the promoter or promoter group. But then it can be a long list of persons who may be deemed, if we are start searching for person acting in concert of each of the persons who are disclosed in the promoter group. So there may be huge list of persons who may be disclosed there. So that I think that may be just a Pandora's box. I don't think that should be a relevant thing. It is better not to disclose anything.
But Manoj, what if suppose in case of an open offer, as a part of the offer, it has been disclosed that there are certain PSEs who are acting along with the promoter as a part of the offer document, and those person acting in concert continues to hold shares of the company post completion of the takeover offer, then for the purpose of the shareholding pattern, is company under obligation to disclose the same as person acting in concert? Because at the time of offer, they were person in acting in concert. So long as they are holding shares, will it not be deemed that they are person acting in concert, or company needs to have some kind of declaration from such persons that you continue to act?
So what you are saying is correct. If someone is helped in acquiring the company and he becomes a co-shareholder of the company and becomes the co-promoter one time, then it's fine. But if it is not, that person may not be a shareholder at all. It is just financing arrangement, right? So private party is financing to acquire another listed company and hence is being shown as a person acting in concert. Then in that case, it is absurd situation to disclose that person as a person acting in concert. He may be just a financer, right? Private financer. So yes, a company must take consent from the person before disclosing his name. That would be a right thing for the company.
I'll just flag one more perhaps dimension to that. Sometime back, SEBI came out with the discussion paper to do away the concept of promoter and bring the concept of person acting in concern.
In control. Person in control.
In control.
Yeah.
So is that a step in that direction where SEBI wants to test the water before actually judge and mandate the provision of implementation of person in control by taking some, you can say, a survey kind of thing, by checking the shareholding patterns of the company as to what is the position that is going to emerge out of that, and will it be really be feasible or not? I'm just throwing an idea whether it is the intention behind that, or because otherwise, as you have been discussing and Manoj has been answering, I agree that it has to be a long term. It cannot be an event to event person acting in concert. As to for one particular transaction, the person was considered as a person acting in concert. Whether he will be considered as PSE for shareholding pattern also or not is a different question, definitely required to be deliberated. And it cannot be just be put because the person was there as a PSE in one of the transaction, he'll be added. So this may give some absurd result also in some of the cases. So I'm still, because this amendment came just yesterday only, I could not think much about, but these 2-3 things are coming to my mind. Perhaps that also can be one of the area where the government has thought to just do some kind of exercise before actually implementing that provision.
Sir, I don't think, Amit, I don't think this can be an intent. It is, I think, more of a transaction perspective. There has been many of the cases where persons have dealt with share in some manner collectively, and they are not no way to trace them. So if something is traceable, they want to take help from the corporate and say, okay, these persons were acting together in some case. So their account may be checked at the time if there is some, let's say, insider trading allegation or some FUTP allegation. They can easily check those persons' account. That is the additional validation they want from the corporate to help.
Okay, now one question to Manoj. I'm asking you.
Yeah.
Because you are handling this open offer, and there are 2 types of things. They have given category. The who can be, you can disclose. So I have shares and I don't have shares. So these formats are covering both, or these coverage only when you are holding shares?
Sir, shareholding pattern, I think for promoters and promoter group, they have said that whether or not you are holding a share, you have to disclose their name, right? So if once a person was holding share and disclosed in the group promoter group category or somewhere in the shareholding pattern, their name cannot be taken out by the company voluntarily. That is the present position. So if a person is holding share once, and its name was disclosed at PSE or otherwise of the promoter group, then it will continue to be disclosed. It is very difficult to remove their name. But for takeover regulation, there is no such provision. It is transaction specific. there may be 7 persons who are part of the family, but only 2 are participating in this takeover offer, even if it is part of the same promoter group. So let's say existing promoter of a company is giving takeover open offer because of some default or because of breaching the annual creeping limit. They will give the open offer, but in that they will not disclose the list of all the persons as PSC. Only 1 or 2 person maybe who have participated or who are supporting in the offer process or who have contributed in the 5% limit breach, they will be disclosed as PSC, not all the persons.
Okay, so suppose I don't have shares and I'm a promoter or I'm connected to this, my name should be disclosed or not?
No.
Yes. No, if first time disclosure, we have option to check, but if it is disclosed, then we cannot remove it.
I'm not saying disclose, not remove. I'm not holding shares, but I am coming into the category. My name should be disclosed or not?
In the public category, sir.
Yeah, it's their name should be disclosed.
Not in the
Promoter category he's asking.
Promoter. Once a promoter, always a promoter, unless reclassified. That is the present position. So yes, whether or not holding share, he should be disclosed.
My query is because there is a confusion always. I am coming into the category of various category of shareholding as per shareholding pattern, but I am not holding shares. So the person who is not holding shares should be disclosed, or the person who should have shares should be disclosed.
So that is what I'm saying. For the purpose of shareholding pattern, if a person is not holding share and he is part of the promoter group, he may not be disclosed at all. But if once he acquire a single share and his name got disclosed, then removal from the list will be difficult. It has to be, the process need to be followed.
Okay.
So one point I think coming from what Manoj has mentioned, there is a provision for reclassification from promoter group to public category and vice versa both. But there is no provision or regulation for reclassification of a promoter to promoter group or promoter group to promoter. And this discussion is very important in context of the changes what SEBI did, which were effective from 30th of September 2021 return. Because prior to that, as I was mentioning, the 5 decades, the company shareholding pattern was quite jumbled, wherein many companies were having, let's say, 20 promoters and promoter group. They had not ever reclassified, they had not ever
regrouped, yes.
Regrouped as to who will be promoter, who will be promoter group, because their one category was required to be put. So they have put one category. Now they want, so what should be the basis? Should SEBI come out with some scheme under which they are given one-time opportunity to justify as to who is actually a promoter as per the current regulation, and whosoever will classify as a promoter group. So a one-time kind of opportunity may be helpful to clear the discrepancies what the corporates are having. Of course, with the checks and balances. I'm not saying without that.
Yes, this is very important, because in many of the cases we have faced in one case where let's say the promoter was the single individual, and due to his death, his shareholding was gone to the wife of that promoter, right? But the 2 or 3 sons were already managing the affairs, were the managing director, and they are in the control. But they were disclosed as promoter group earlier because the main person was the chairman, and he was disclosed to be the promoter of the company. So now nobody is promoter in the company, or the lady who has got by succession or by will became the promoter, but she has no role in the management of the company. So that is not the correct position. The 3 brothers should be promoter, and the lady who has got the share of husband may not be part of the promoter, but just a promoter group person. So this kind of things, there should be discretion. I think that discretion may be exercised on the request of the promoter by the board of director and intimated to the in the next shareholding pattern. That decision may be taken. I don't think that for that there is a requirement to have some change in the law. Interseed allocation.
They have categorized the institutional domestic investor mutual fund, venture capital, alternative investment bank, insurance, provident fund, ARC, sovereign wealth fund, NBFC, other financial institutions. So they have categorized all types of investor. So anybody wants to judge and do this, that is a, I think, good move. Only thing is the relative.
In the public category, yes, that's as much disclosure as easily can be achieved through the RTA data or DP data should be disclosed. That is not a problem, I think.
Please ask this question: shareholding pattern, who will take relative as per Companies Act 2013? Answer is yes.
Yes, I think relative as per Companies Act 2013.
So,
Okay, so moving ahead, I'll now pass the baton to my colleague Ravi to discuss the further amendments. So Ravi, up to you.
Thank you so much, sir, for laying down the path. Now, starting with this amendment has been made by SEBI on 7th of June, and it's a partial modification to a December 2018 circular, which provided for cyber resilience and cyber security measures by depository participants and stockbrokers. Now, before we get into what is the modification, let us understand why this is required in securities market. We all know that after the OTC, over-the-counter trading, it has now become electronic. And these systems, these electronic system and the internet interface plays a key role in running the infrastructure of entire securities business. Therefore, the electric hardware as well as the internet-facing firmwares being the platform, being the vehicles on which the securities market is performing, it is very important that these intermediaries have robust security measures at place so that any untoward incident is not, or a fiasco, I would say, is not taking place. Now, this comes as an aftermath of Colo, which is famously known as collocation case of NSE, and also the dark fiber case. We know that there were some security breaches at exchange which were investigated by SEBI, and they thought it fit to implement these measures across the market. Now, it is a matter of another question whether these measures would be extended to other securities market intermediary. I feel yes, with time these would be extended. Now, let us see what are the modifications. First, these can be classified into three parts. One is identification. Second, regular updation. And third is the audit. Now, what they have to identify, these intermediaries, two classes of intermediaries, which is brokers and depository participant, is their critical assets. Critical assets being defined by SEBI, and it's an inclusive list, not exhaustive. They say that all business critical system, internet-facing applications, which is usually used by brokers, systems that contain sensitive data, sensitive personal data, and sensitive financial data. And very interestingly, personally identifiable information. Now, this amendment comes in 2022 when the PDP bill, on which we have already done a webinar in past, is on its way to become a legislation, and India becoming few of the countries in the world to have its own data protection regime in terms of legislative exercise. Now, all these informations, because big data, regtech, fintechs are the concepts of the day, and this is going to be more complex going forward. They want these cyber security measures to be implemented at this nascent stage. So the framework of the legislation, which is going to be the most engaging area for the legislator, the Indian legislature, to prepare a bedrock of this safety measures. Now, they have also said that whatever critical system you identify, all the ancillary systems to access or to operate the critical systems would also form part of the critical system. So if the broker is using a particular application or a particular internet service, which is very critical to the functioning of business, all the accessories, all the peripheral architecture which is used to connect to that or access that system would also qualify as critical asset to that stockbroker. And then they have to prepare an updated list after identifying. They have to keep it updated. And probably there would be, and there is already in the December 2018 circular, there is a provision of inspection and disclosing it to the stock exchanges, because they are the members of stock exchanges and depositories respectively, and to the board as well. Now, second is standardization, or I would say strengthening of the vulnerability assessment and penetration tests. Now, these VAPT tests, ordinarily known, were being conducted by brokers and depository participants earlier as well, but these were not regulated. Now, what they have to do is they have to conduct these tests through a CERT impaneled service providers. CERT is known as Computer Emergency Response Team, which is the nodal agency, operates under the aegis of Ministry of Electronics and Information Technology to tackle any security threats on the Indian internet domain. So therefore, they have to now get it done through the impaneled persons only. And then they have to conduct this VAPT at least once in a financial year. Earlier, there was no such requirement. They were advised to do this VAPT on regular intervals. Maybe you can say it was on need basis, but now this has been made mandatory, and an audit report is also required to be sent to the stock exchanges. All the gaps which would be which would forthcome upon VAPT test have to be remedied on an immediate basis, and whatever gaps or deviations are found, they have to be reported to the stock exchanges as well as to the depositories. Now, the board proprietors, board members, proprietors, in a sense that in whatever structure these broking and depository businesses are being operated, the persons who are at the helm of these intermediaries are made responsible that they would ensure compliance with these requirements. It's a very confidence-imposing move, given the situation in which we are living right now, because use of technology has increased the reach so much so that these genuine intermediaries, and along with them lot of untoward elements and lot of elements which are not desired in securities market, they can also reach to investors, and they also run their parallel systems. So they have ensured that no one is interjecting with their systems, and also no one is able to reach to the investors by deploying these mechanisms, by intercepting these systems. Can we move to the next one?
Yeah.
Next is the notice of SEBI. This is of 10th of June.
Ravi, just a minute. Can you tell on cyber security whether all trading applications need to be classified as critical assets?
Yes, all of these would be classified as critical assets.
Okay.
Because these are internet-facing applications usually, and they have to be classified as critical assets. In fact, whatever tool, whatever systems they have deployed to access these applications, those are also critical assets. Now, moving on with the next notice of, and it's a public notice by SEBI, the participants as well as the audience must be receiving a lot of messages from unscrupulous service providers that you invest, we have an algo software, you invest, we would give you this much of return, assured returns, sometimes astronomically higher returns. So therefore, in order to curb this, lucrative offers from these unscrupulous providers, most of them who are not even regulated or registered, SEBI has issued a public notice saying that please do not fall prey to these algo providers who claim to provide you assured returns or high returns on your investment, because SEBI has not deployed any kind of investor grievance mechanism for these kind of entities. It is another matter that SEBI would crack down on these persons who are floating these, who are soliciting investments without seeking registration as intermediary, but as a prophylactic measure, as a precautionary measure, they have warned investors that please do not fall prey to these kind of lucrative offers, because there is then, if you fall prey, there is no real mechanism for bringing your money back. Yes. Now, next we have this classic fraudulent and unfair trade practices matter. This belongs to 2008 and 9. The illegal activities of rigging the price and rigging the volume of this scrap called Sterling Greenwoods Limited pertains to 2008 and 9. The case has a very rigmarole history. It went into a lot of adjournments. A lot of time was taken in culminating this matter. This matter went to SAT twice, came back, and finally the charges of fraud were upheld. Now, this was a classic FUTP matter in which the persons who were controlling the company, the listed company, they passed on funds as well as the shares. And I'm saying this from the order, and this is the observation, that they passed on some shares and funds to a group, the group who was responsible for manipulating, and then the group rigged it, played with the shares, and increased the price and increased the concentration of shares in their hands. And after the price reached to high levels, they dumped it in the market and exited the market. Now, why we have picked this order is because of the fact that this order has a very interesting element. Usually, when you read a SEBI order, you would rarely find a section where the disproportionate gain or unfair advantage has been quantified. Although this is a prescription under Section 15J of SEBI Act, that while levying a penalty, you have to determine the quantum. But this is very difficult for the regulator in many cases. But this is one of those rare cases where this unfair advantage has been determined by the adjudicating officer, and then the penalty was levied. Can you move to the next one? Yes. Now, coming to the classic case of Sahara, I'm sure everyone must be aware of this matter. This also pertains to same year, 2008 and 9, and pertains to the public issuance, which was under the garb of private placement by the Sahara entities in the form of optionally fully convertible debentures. I'm not going to the history of this litigation and all the contours of it, because it would take the entire time of this webinar if we get into it. But now SEBI has adjudicated this issue and imposed a penalty of approximately 12 crores on the offenders. Now, what is interesting in this is that Mr. Subrata Roy Sahara, he took an argument that I'm neither the director nor an officer in default in these companies. So therefore, I should not be visited with any penalty. The adjudicating officer, and it's a very good order, one must read. He has analyzed and observed that because he was the controlling shareholder and a promoter in these companies, and that without his instructions, this entire scheme could not have been framed even. Therefore, he has been held to be instrumental. And the clause, which is a very debated clause in the Companies Act, wherein the clause says that when the board is accustomed to act on the instructions of a person, that person is also considered to be an officer in default. So he has been penalized under that clause. While it remains a matter of, we would only see it in future because they would challenge it. The basic challenge they took against this adjudication proceeding was that our appeals are pending in Supreme Court, and you cannot decide this matter when the matter is already sub judice. Although
Ravi,
yes,
on this matter, how they use the provisions of Companies Act to determine an adjudication proceeding under the SEBI Act, that's an important question. And in past, has SEBI has ever used such kind of provisions of the act to levy penalty on the controlling shareholder?
Very rarely, but there have been instances. Now, the reason why they have referred to the officer in default provision is because the entities who floated this entire OFCD schemes are companies. Secondly, if you see the provisions of SEBI Act, the penal provisions wherein the liability is determined is also framed in lines, and you would find it everywhere, wherever, because of a corporate entity or because of a separate structure, a penalty is going on the persons who are controlling it. You would find the clause is written on the same principle of law, that whosoever controls it. So therefore, they have penalized Mr. Sahara on applying this principle. Can we move on to the next one? Yes, now this is particularly interesting. So the heading itself says interplay between Depositories Act and Contract Act 1872. You must all be aware about this matter. It came in May 2022. Cases by name of PTC India Financial Services Limited versus Venkateswarlu Kari and another. He is the IRP in this matter. It is a matter which comes out of IBC regime, but it touches upon a lot of aspects of Contract Act, Securities Law, as well as IBC and valuation also, which is lesser debated aspect of this matter. What happened in this matter is very simple. This company advanced a loan to another company, and the holding company of the borrower placed shares of some other unlisted company to this lender. Now, after 2 years of lending that amount, and these were odd 31 lakh shares of that company, which the holding company, which is known as Mandava Holdings, placed with the lender. So after grant of this loan, immediately within 2 years default occurred, and the lender, because there was a pledge agreement, the lender under Regulation 58 of Depositories Act gave a notice to the depository to become beneficial owner, and notices were also given to the borrower as well as Mandava. Now, where the controversy arose, how this matter reached to Supreme Court, the controversy was this. Mandava said, now let me add another leg to understand this matter. After this default, PTC moved a Section 7 application as a financial creditor against the borrower company. However, as it happened, the borrower company had also filed a Section 10 application, and that Section 10 application got admitted. So Section 7 was withdrawn, and PTC was asked to file the claim along with proof of being a financial creditor. Now, here the interesting episode starts. Mandava also filed its claim as a financial creditor, and PTC also filed its claim as a financial creditor. And the subject matter of both those claims covered these 31 lakh shares, 31 odd shares. Now, Mandava's line of reasoning was that because borrower has defaulted and PTC has become the beneficial owner of these shares, I am the financial creditor. PTC said, no, I have become a beneficial owner only as by following the procedures of Depository Act under Regulation 58. And I have not become the actual owner of these shares by following the process of Section 176 and 177 of the Contract Act. This was the narrow controversy on which this case was being fought. Matter reached to Supreme Court, and this is the verdict. Supreme Court says that Depositories Act as well as regulations, they do not override Contract Act. Number one observation of the Supreme Court is this, that the Contract Act is not an exhaustive statute. It gives the four corners, it lays down the four corners, but it does not describe what form, what manner you can do things. The rule is, so far as you're not violating the provisions of Contract Act and the principles of common law, justice, equity, and good conscience, the contract is valid because the contract runs on separate, different premises. Well, the argument of Mandava was because they became the beneficial owner in the records of depository, there is nothing needs to be done. They have taken away the asset and they are the owners. So we are the financial creditor. They have recovered what they wanted to recover. Now, another dispute on this particular aspect, because they had lent some close about 125, 126 crores, and the PTC was saying that the value of these shares are only 18 crores. Mandava was saying these are more than 1,000 crores. That was another issue. But on the legal point, the issue was that whether by following the process laid down under Regulation 58, Sub-Regulation 8 of Depositories Regulations, and the corresponding sections, one becomes the owner as if such invocation of pledge results in actual sale. Now, these words are very important. Actual sale. Whereas one would say in common parlance that this is a sale, but the word used in Contract Act for these two provisions, 176 and 177, is actual sale. So the Supreme Court said that no, this is not an actual sale because he has just taken it in his name to secure the asset. The pawn, which is called PAWN, or the pledged asset, they have only taken the security of the pledged asset and it is not the actual sale. And as per 177, the pawner still has the right to repay the loan and get those assets back on full repayment of loan or whatever, on full satisfaction of the contractual terms. So therefore, PTC was recognized as a financial creditor and this appeal was allowed. And this was, of course, filed against the orders of NCLAT, which rendered the decision in favor of Mandava.
So Ravi, the fundamental question here, which is the point of concern arising out of this judgment. So if PTC only gains the status of beneficial owner, so then for the purpose of Companies Act, for that company, who will be deemed as a member and who will exercise the voting rights?
PTC.
But if PTC, because suppose that I read certain articles, including those of some proxy advisory firms, where specifically they talked about the Z case and held that on account of this judgment, Yes Bank shall not be allowed to exercise the right to vote since they are not the owners. But for the purpose of listed entities, any person whose name appears as a beneficial owner in the records of depository as on a particular date is only eligible or capable to exercise rights over those shares. So if even for procedural aspect, I took the shares in my custody and I kind of become a trustee during the course of time, I will be treated as a beneficial owner and then I should be allowed to exercise the voting rights.
Yes.
But I think there are certain views contradictory to that this person should not be allowed to voting rights. This is something which is being taken out of this verdict. And another important point is that the debt can only be discharged only and when these shares are sold.
Yes.
Either the amount is repaid by the borrower or it has to be sold. And they have very, very specifically stressed on a specific word which is used under the Contract Act with respect to pledges on the word that is called bailment. They have specifically stressed on this word. So the only point of contradiction is whether the beneficial owner gets all the right to the to exercise the voting, because I think the sense in which the beneficial ownership has been mentioned in the judgment is not the sense in which it is used under the Depository Act, that a person whose name is entered becomes a beneficial owner. Per se, he becomes a beneficial owner. It need not to be justified or established. The way it has been used, beneficial owner, I think it has been used in the sense in it is being used under the Companies Act, right, where there is a registered owner is a different person and the beneficial owner is a different person. And the benefits of the shares goes to the beneficial owner, but the right to vote is exercised by the registered owner. But in this case, as soon as the procedure of 58 regulation is triggered, the name is substituted. So finally, if my name is there, then I would be only allowed to vote as per the law of both the listed entities and the Depositories Act under the LODR. So this was the question that who is eligible to exercise the right of vote.
Yes.
Right of vote would remain with the beneficial owner, who is the basically lender right now, BTC Financial Services. Because Companies Act is separate. It specifically recognizes the beneficial owner whose name is there in the list of beneficial owner of depository. So irrespective of the nature of the, no notice of trust can be recorded by the company and considered by the company for the purpose of voting right. It is just a there are two different acts. Contract Act is separate, where the purpose is contractually recover the money by the lender. But here it is with respect to Companies Act. If the name is there, company will not go deep into it and find out who is the whether it is contractual or otherwise.
Okay, but I think the fine line of the judgment, it seems that Contract Act will supersede the Depositories Act provisions.
Only with respect to actual ownership.
Because otherwise, previously, specifically with respect to right of nomination, and there are other laws where it has been very well held by various courts that law of contract will supersede depositories. In case of nomination, the only act as a custodian. You only act as a custodian. Right. So here also this was the only fundamental question, is that who will exercise the voting right. The sense, as I mentioned, beneficial ownership used by the court in the judgment is in line with the concept of beneficial owner under the Companies Act.
So I would try to resolve this. You see, when the pledged asset or the pawn is a dematerialized security, then the lender is in fact playing two roles at the same time. One is of the lender, and second, the custodian of that pledged asset. And it is the mandate of Section 176 of Contract Act that before the lender can sell those shares to recover the debt, because lender has both the options available, to sue the borrower or to sell the asset and recover the debt. And if there is still a shortfall, he can still sue the borrower. Now, to get that status, he has to mandatorily register he has to mandatorily follow the procedure under Regulation 58. So that's the mandate of depositories regulations. Now, once he becomes the beneficial owner, it will again depend on the terms of the contract, whether the pledgee would exercise the voting rights or not. In this case of PTC, I think it's para number 12.6 at page number 83 of the judgment. They have said that as per clause 2.3 of this particular contract of pledge, it was PTC who was to get the right to vote in case there was an event of default, and so far the event of default continues. And this is usually a commercial practice. So it is for the parties under Contract Act to envisage those commercial nuances if at all the default occurs. Now, so far as the interplay between Depositories Act and Contract Act is concerned, Supreme Court has laid it down very clearly that either of them would not supersede each other, and one has to harmonize these two acts. Yes. And they found that the only conflict between these two laws were only with respect to this process of 58 sub-regulation 8, read with Section 176 and 177, that once I register myself as beneficial owner, whether I will still remain the financial creditor, which of course I would remain, because I have not sold those shares. The actual sale has not taken place. And Mandava was saying, no, because you have become the beneficial owner, your debt is discharged. You are no more the financial creditor because you have taken away the asset which was pledged with you. So that was the narrow controversy between them. So I think there are a few experts who are also saying that how then account for these pledged shares in our books? If we are not the owners, what side of the book we should show it? So these are the nuances which are coming up.
Ravi, I think very rightly and beautifully articulated the entire judgment. The sum crux remains the same. As far as the position of a pledge is concerned, I think there has not been any controversy around, and there is a full clarity. Unless the terms of contract otherwise provide, the voting right always remains with the pawn, the person in whose name the securities stand. So in this case, the securities were standing in the name of Mandwa Holding. So they were supposed to exercise all these rights wherever whosoever is a registered owner, right? As far as, because they have a specific contract which was saying that the voting right on exercise of this pledge or on devolvement of this pledge will go to PTC. Because of that particular provision, perhaps the voting right was to be given to them. Otherwise, I don't think it is not the established position of law that voting right will go just because the person has registered his name to follow the Depositories Act process to get the sale completed. Because as you are referring 176, 177, essence is that sale, for the purpose of facilitating the sale, his name is to be entered in the register of member, nothing else.
Yes, you're right. That's succinctly the point.
Amit, we have to just now stop this topic, please, because time is short and we have two very important. So over to insolvency. So please.
Manoj, you can
Manoj, you will
take this forward.
Amit, you start.
So I'll begin with. So there are a couple of changes. I think some 3 or 4 major changes have been proposed and have been made as far as the insolvency law is concerned, where we know one of the provisions is that to overcome the administrative delay, because the law says that IBBI has to be reached out wherever the name of the insolvency professional or resolution professional or the liquidator has not been proposed, then there would be a consent of Insolvency and Bankruptcy Board of India for the purpose of appointment of a respective professional. To overcome the delay, the IBBI has been creating a panel every 6 months for the respective national company law tribunals jurisdiction. And from their panel, based on the name whosoever are appearing over there, the Insolvency and Bankruptcy Board list out the name of people and professional who are qualified to be appointed. So I think that is one panel which has been suggested for the purpose of a period starting from today, that is 1st of July till 31st of December 2022. And again, for the 6 month period, the panel will be going for further change. Now, important thing is that I think the takeaway is that the government has further stringent the provisions of this panel. Earlier also, there were restrictions that once your name, you have given your name, you have volunteered your name to be included in the panel, and you have been given an assignment by the adjudicating authority, you cannot have a liberty to withdraw your name. You cannot withdraw your consent for being appointed as a interim resolution professional or as a resolution professional or as a liquidator. Whether you like or not like, I think there is a lot of stringency provided in the regulation or the guideline itself that to maintain that sufficient number of people are available for the purpose for which the panel has been created. I think that is one limited amendment that the change the government has done. I don't think there is any point for discussion.
Yes, I think it is just a database related information. Yeah, so that you have already covered. Yeah.
So maybe you can move to next one. So I'll take up this also. IBBI has amended grievance and complaint handling procedure. The major change in respect of these amendment is to one, grievance and complaint handling regulation 2017 has been amended, and the other one is the inspection and investigation regulation 2017. So when we come to inspection and investigation, the major change is the replacement of the word client with the word stakeholder, and that is coming in context of complaint as to who can be a complainant. Now, earlier, the board was having the power to take cognizance of complaint from a client against the insolvency professional or the resolution professional or the liquidator. Now that client word has been replaced by the word stakeholder. What does that mean? Because in insolvency resolution process, the stakeholders could be your financial creditor, could be your operational creditor, could be your committee of creditor, could be your shareholder, could be the other. Stakeholder definition is very wide. I think as far as the insolvency professionals are concerned, though it was not very specifically provided and client's definition was also interpreted, but many of the cases had gone into dispute. So perhaps the regulator had thought it fit to make necessary changes in the to enable the process of inspection and investigation in a smooth manner. Otherwise, they have, you can say, provided the very crisp timeline, the timeline which was providing 45 days time for the purpose of grievance and the complaint redressal. That timeline has been reduced to 30 days. Either you have to dispose of, either way, either they have to accept that grievance or complaint, or they have to address that. That is one. An online complaint redressal portal also has been launched or is proposed to be launched that will function. That web-based facility will be provided that you can go on the web and launch the particular grievance and the complaint, and it will be addressed in a seamless manner. I think that's the change that the government has primarily done. Manoj, if you have anything.
Yes, I think yes, and they want to increase the role of IPAs, the agencies who have enrolled these insolvency professionals, so that they can do the first level scrutiny and try to handle grievances against any insolvency professional. And whatever the outcome of the disciplinary committee's decision will be intimated to all the COCs wherever they are working as a insolvency professional. So that, and similarly that copy will go to the adjudication authorities where the matter is pending. So these are just additional information related thing. But yes, it is a good thing that separate portal will be there, similar to the score portal of the SEBI, and that would fast track the grievances.
Okay, next.
This is another important change that the government has made with regard to the information utility. We understand when the law was insolvency and bankruptcy code was adapted, then information utility concept was evolved for the first time. And the concept was that to meet the timeline of 14 days that the mandate that insolvency and bankruptcy code has given, that adjudicating authority shall dispose of the matter within 14 days. And we have seen the matters being pending before the adjudicating authority for the last more than 3 to 4 years time. And still the adjudication process has not been completed. With that objective, information utility concept was given. And the concept was that there will be one information utility in India where when the lender will lend the money, the information will be submitted to the information utility. And information utility will send the information to the borrower. And borrower will have to give their confirmation or denial as to whether they are in agreement with the information what has been given by the lender or not. Either they will agree or they will dispute. However, it was felt that when the information utility was sending these all information, the borrowers, of course, were not reacting to that. They were not responding to that. And many a time the response was not there and the information was kept in abeyance. Government later on amended the provision and they said the 3 opportunities will be given by the information utility to the borrower to accept or reject the application, whatever has been submitted. After 3 attempts, if the information is not responded, it will be put to the category of deemed to be accepted. So deemed to be accepted condition is like now there will be 3 categories, 1 green, 1 red, 1 yellow. So green is one where the borrower has given the acceptance and lender has filed the information, borrower accepted that, that is green. That is both of the parties are in agreement. Second category, red, where the lender has given the information, borrower has disputed, that is red. Now, third category is that despite repeated reminder, 3 reminders, the borrower is not responding, that is now categorized as a yellow. Now another important change that has been made is the section 7 and 9 application. It has been made mandatory that before the application could be filed by any of the creditor, the information of default has to be submitted to information utility. Now, I am not able to comprehend, although this attempt was made perhaps in May 2020 also, when the COVID was going on, and a circular was issued by the adjudicating authority principal bench that a certificate of record of default will be mandatory to enable the processing of application. However, the circular was later on withdrawn because it was not having any legal basis, that is insolvency and bankruptcy code was not amended. Though I am not very sure as to whether the necessary regulatory amendment has been done as of now also or not, because I could not find except one place where it says that it is an obligation on part of the financial creditor or the operational creditor that before filing an application to adjudicating authority, they have to file the information of default to the information utility. There could be well understood process, that well understood purpose as to why the government wants this information to be there, so that the certificate of authentication of default can be submitted along with the application to the adjudicating authority to facilitate the faster disposal of application. But still the regulation has not been amended to make it mandatory that this authentication of record is required to be attached along with the application. So how it will actually fast forward the processing of application, that I am not very sure. But yes, the changes have been made. I think Manoj can.
Right. I think they are trying to utilize the information utility to the fullest extent, but practically I think still it is, if there is a yellow kind of situation or if it is a red kind of situation, how they will issue the record of default, that will be a challenge. Then it will be whether it can be a disputed case even in section 7 cases, that need to be checked, because section 7 is a straightforward case rather than section 9, where there is a requirement to give a prior notice and opportunity to dispute the amount being claimed by the operational creditor. So section 7, where it is a financial creditor case and still the borrower denies or does not respond, then what will happen? So those are the issues. There has to be a robust system, and law should provide, act should be amended, the IBC code should be amended to facilitate the same.
Yeah, yellow cases alone, I am not much worried, because those cases may be disputed cases, what I understand. But in respect of other green and red cases, at least the mandate should be there from the regulatory framework that this certificate or authentication of default is now mandatory to be attached along with the application. I think that is not yet coming in black and white as far as I am able to read out. But let's hope that government is planning to implement.
But they are saying Form D need to be given by information utility. So if you are filing it and then you get the Form D, then you can attach it, and that will make the case simple for NCLT to admit or not to admit the case.
Yes, indirect inference is there. I agree. But
Amit, Manoj, time is short.
Yes, time is short, so we may go faster.
IBBI amendment on CRP regulation, just explain this process.
Sir, basically the first amendment, these are the basic, the highlights are given. The first one is that operational creditor, whenever they are filing a claim that there is a default, they should also give supporting document like GST returns, GSTR1 and GSTR3B and eBay bill, so that it is easier to verify the claim of the operational creditor. The second one is with respect to application under section 7 or 9. here creator need to file the details of PAN, email ID for the smooth correspondence. So that is also simple thing. Then proper information movement. They are saying that this is the obligation of the operational corporate debtor and promoter to provide all the assistance to the RP. This is already coming from the law itself, that they have to cooperate and provide all the supports as may be required. Next page. So another one is, I think, with respect to it is the duty of the creator. They are saying that the creator will provide whatever information they have regarding with respect to the assets of the company, financials of the company. So sometimes it is found that the corporate debtors are not cooperating, or they have not filed the financial balance sheets and other information. So whatever informations are available with the creator, they should furnish it, so that resolution professional can make a proper information memorandum based on those information. Many of the cases, information memorandum remain incomplete or not satisfactory for the resolution applicant to make a proper scheme or proper resolution plan. So they are saying that the creators would also supply all the information they have.
I think, Manoj, it's a very welcome move, because the biggest hurdle that the government so far, which has not been able to compel the financial creditor, especially to come forward and give a support. Though there was a code of conduct proposed for the financial creditor and the committee of creditor as well. Notification was also issued, but the code of conduct could not be notified so far. I think it is a step perhaps in that direction, that the regulation itself has got amended, wherein these type of changes have been included. In addition to the balance sheet and the other financial information, what has been specifically provided is the extract of a forensic transaction.
Okay, that is what
it was, because if you know the timeline in which the insolvency professional is working, on 75th day from the commencement of CIRP, he has to form an opinion as to whether the avoidance transactions are in existence or not. And he gets another 40 days time to determine whether the transactions are there or not. Now, he keeps on struggling with the financial creditor that you already have conducted a forensic audit. Why don't you provide us the report? So he is never getting those reports and the support from the financial creditor. Now, when the specific mandate is there and it is on record that the forensic audit was conducted, perhaps it could help the insolvency professional in forming his opinion, as well as converting all those red flags into the determination and filing of the avoidance transaction application also in that time. I think
right.
That is a very welcome move.
Yes, I think this is a very good move. Another thing is, I think, though in many of the cases it is already settled that all avoiding transaction and their treatment must be there in the resolution plan. So there are many of the cases. In many of the cases, the avoidance transaction related application is filed with NCLT under section 66, and that they remain in pending for long, even after the resolution has already done. So what will happen to the recoveries, if any, from those proceedings is not dealt with. So that may be a problem, and there may be a dispute whether this should go to the resolution applicant or this should be to the creditors who have filed their claim, or stakeholders who have filed their claim, may not be clear. So this regulation amendment is there, making it that there should be a specific provision with respect to all avoidance transaction and their treatment. So that is also a good thing. Then another is, I think, valuation. If there is a significant difference, then there is a provision that a third valuer may be appointed. So what is that significant difference? That is being defined, and obviously in such cases, a committee of creditor would have option to tell the resolution professional to appoint the third valuer to check the valuation aspect.
But on the previous point, Manoj, still we feel that the avoidance transaction applications are not getting concluded because the timeline is very short. We After resolution, it's nobody's baby, because the person who is the resolution applicant, he has already discounted whatever are the avoidance transaction. He is not interested. So the difference what was supposed to bring by virtue of avoidance transaction, see, there were only two deterrences which insolvency and bankruptcy code brought in. One, it will change the management by virtue of 29A. B, because of avoidance transaction, the SFIO, CBI or other investigation might get triggered against the promoter. Now, these were the two deterrences which brought a lot of behavioral changes in the society. Now, if we see that in the past 5.5 years of time since the inception, though in the beginning of the time there was a fear of avoidance transaction and CBI, SFIO and other thing which was happening also in many of the matter, over a period of time, this avoidance transactions, applications and their conclusion has been minimized, leading to a change again in the behavioral structure of a society. Again, we are not seeing that there is any deterrence in the society. So government has to think about the avoidance transaction application conclusion also, whether they are required to develop it as a separate institution so that it can logically be concluded. It should not be a happy marriage that a resolution applicant is coming and resolution is done and he is not proposing anything and the avoidance transaction application is dying its own death. Otherwise, this
we have a very short time now. You have to cover the changes also, and then some question answer also there. Manoj, quickly,
So first one is basically appellate NCLAT's judgment with respect to ILFS, new board of ILFS. So they have decided, I think interpretation which is written may not be correct here, but the thing is that they are saying, because in case of ILFS there are two kind of consideration. One is cash, which is 11,296 crores, and there are units of invest having value of 55,065. So they are saying that the distribution of these cash interim money should be in pro rata basis to all the creditors as per of various entities within it, because it is not a single person, single company resolution. It is a group resolution. So in all the cases, there are many companies and their subsidiaries also, and lenders are there in different stages. So they should be given on the basis of their contribution to the overall value of the claims, and based on that, this distribution should be there. I think section 53 reference may not be there, but that is the intent, that this distribution, interim distribution, should happen on the basis of their logical share in the total claim. That is the intent.
Okay.
Now, Manoj, only point is that tomorrow, if there is a need that some other distributions are to be made and we are not able to adhere the 53 section itself, then what will happen?
No, they are saying that from the interim distribution, they should obviously make the provision for whoever have not supported it, or who have basically dissenting creditor or whatever their contribution, that will be taken care of even from the interim distribution, because there are the second leg of distribution would happen to only those persons who will continue to be the unit holders. So that's why they are saying this kind of provision need to be made.
I think we should move on this now. Amit, please very briefly discuss. This is a discussion paper has come out from Insolvency IBBI. So Amit, very briefly, because we have to cover question.
I think this is a very welcome move that was a demand from the entire insolvency resolution fraternity, insolvency professional fraternity, with regard to the remuneration of insolvency professionals. So there are two limbs to it. One, how to identify what is the remuneration that should be paid to the interim resolution professional or to a resolution professional or to a liquidator. Number two, to ensure the mechanism that those remunerations are paid. I think second part was more relevant, and that is requiring more addressal. Now IBBI has came out with the discussion paper saying that these are the recommended minimum remuneration which we expect in the different kind of scenario to be paid. Now, I'm not going into what all the parameters are, but yes, in some short, it says that yes, if your matter is of so and so nature and these are the parameters, you will be entitled to so and so remuneration. I think government needs to do a bit more towards the second part of the problem also, that is how to ensure that the remunerations are paid in time to the interim resolution professional or to the resolution professional. The other part of the discussion paper, what the government has came out with the enablement, up till now we know only the individual insolvency professional were allowed to be appointed as a interim resolution professional or as a resolution professional or as a liquidator. Now government although has allowed that there could be a concept of insolvency professional entity where you can have a majority of insolvency professional and minority can be there as a non-insolvency professional also. With a capital threshold of 1 crore, you can form these entities, and these entities could initially provide the services only to insolvency professionals who are their member, who are their directors, right? Later on, this relaxation was done away, this requirement was done away, and now the insolvency professional entities could provide the services to any insolvency professional, but they cannot provide the services to directly any of the corporate debtor. Now, government has gone one step forward and is saying that now insolvency professional entity can directly be appointed as a IRP or RP or liquidator. Of course, government will do a middle path where up to a certain turnover or threshold of corporate debtor will be fixed or will be reserved only for individual, and beyond a particular threshold, the matters will go to interim to the insolvency professional entities. So the idea is that because they are going to be much bigger cases, it requires a team to be there to run the process, because it is felt that over a period of time, individual person may not be in a position to have all the resources to implement and complete the whole process. So with that objective, I think it's a welcome move what IBBI has proposed. It will institutionalize the profession of insolvency, because there will be a lot of new research which will come in process, which was up till now not happening, and lot of processes will also get developed. Lot of IT utilization will also happen. So in a way, good for country, good for nation, that we are moving towards the institutionalization of the insolvency regime. I think Manoj can.
Yeah, I think this is a very welcome move. In big size insolvency resolution, it is very important that multifaceted professionals come together and work on the insolvency resolution, so that maximum realization can happen. So there may be a need for financial knowledge, management skills, marketing and investment banking skills, as well as legal and secretarial skills. So multifaceted requirements are there, and for that third-party supports are being taken right now. But if it is done by the same one entity, which is a well prevalent process worldwide, that insolvency administrators are companies or body corporates who have good net worth and good capacity, then I think realization can be much better than as present. So this is a welcome move.
But Manoj, it will not capture the entire. I'm not asking the answer. It will not capture the entire business in the big hand, not the small IPs.
So for that, I think as Amit has suggested, that there may be some limits for which below, let's say below 100 crore claims, there will be appointment of individuals only, and for beyond that, there will be entities who are allowed to participate.
Next. Yeah, Amit, discussions.
I think, yeah. So this one is for the IBBI. They want to become similar to SEBI and become a self-regulatory authority with good resources. For that, they have proposed a higher fee for many of the cases, and new fees, percentage based. All the professional will be paying fees for that.
But it will
So
not
that is the thing.
the total value of the company resolution.
Yeah, so they are asking fee share from the valuers, fee share from the insolvency professional, and even other supporting professionals, including, let's say, so you appoint some charter accountant to carry diligence, to carry financial diligence, some lawyers, some company secretary. So all those professional would require to share their fee with IBBI if they are getting the work.
So on one hand, they have proposed the remuneration surety for the IRP or RP. On the other hand, they have ensured that some kitty comes back to them also, so that their financial strength is continued.
Yeah.
Yeah, next.
Sir, another discussion paper, I think it is also very welcome. Many of the proposals are very good. One is with respect to for every big size corporate debtors, the RP need to make a strategy how they would realize the value. They have also said that there can be restructuring within merger amalgamation or other kind of corporate restructuring, financial restructuring, even during insolvency resolution process time. Generally, it is seen that when the liquidation order is passed, then a scheme can be filed, scheme of arrangement can be filed for resolution of the company. But here they are now proposing to allow even during the CRP process restructuring and resolution of the company through any scheme of arrangement. So that is also, then they are also proposing to allow partial resolution of the corporate debtor. So that is also a good thing. Sometimes it is not possible for insolvency resolution professional to get to sell the entire asset or entire company as a going concern, but there may be interest for one or more units of the business. So that those enabling provisions are also coming. I think overall theme of these discussion papers are there that the resolutions are not happening properly. The realization for the debtors are creditors are very low. So they want to make it more competitive, more friendly for corporate world, and that's why these amendments are being proposed. Amit may add something.
Yeah, only challenge is that all these options, whatever have been opened up, my only worry is that the deterrence what IBC was supposed to bring on the table, it should not get diluted, because the entire thing what society has benefited out of IBC is, one, because there was a lot of deterrence. So a lot of settlements were taking place out of court, and without even going the matter to the adjudicating authority, the matters were getting settled. So leading to lesser default. But all these relaxations, whether they are good or bad, I'm not able to comment at this point of time. But before implementation, these all discussion paper requires a thorough discussion before they are made a law, because they have a serious repercussion. It should not tomorrow happen that we implemented something in a haste and tomorrow we are again going for a U-turn on many of the aspects what the insolvency regime has seen in a period of last 5.5 years. Now, there are many U-turns that we are taking and we have been taking. Now, my only worry is that we should be doing it with a little cautious and examining approach.
Okay.
Yeah. Okay.
Manoj, now I think these are the some amendment they are proposing. Is a concept paper. So anybody has any suggestion, please give it to us. Now there are a few questions which I'm just asking. So first of all, sir, do we have to file Ankit from ESOP in case of granting SR?
If there is no allotment of shares, then there will not be requirement of filing any ESOP form.
Okay. This question is, this is a suggestion. Topics drive majority are closer to proficiency of CSCS legal. Institute should be good governance or no conflict of interest should push MCA to have these tests with more business and strategic related topics. I am CSCS IICA qualified, but we need to allow other professionals to have attract metrics of to attempt this exam. Just my view. He is right. Mr. Malik his point is right that this exam is not only for CACS and advocates or CWA. It is a exam of for the directorship. So it should have some strategical question or some other
Yeah, I
question.
agree, completely agree that these questions needs to be little more dynamics and relating to business more than law relating.
Yes, because a person cannot read entire law which is there. Okay. Is that necessary for a person to get his name registered in the data bank of independent director in order to be able to appointed as independent director, Ankit?
Absolutely, yes.
Absolutely.
So I want to join a company. I'm not passed the exam. I can't join.
Sir, there are two different things. Passing of exam and registration are two different things. Once you register, you have 2 years to give the exam. So at the time of, if you are becoming independent director for the first time, the only prerequisite at that point of time is to get yourself registered. Once you're registered, you have 2 years to comply with the test.
Now 3 years.
3 years in case, yeah.
So what is my experience?
Experience there are other experience related criteria where you are allowed to be exempted from
The
online
registration
proficiency
does
test.
not require-
Registration, there is no exemption on the registration.
Yeah, it is simply registration.
Registration is mandatory for all.
Okay, and then examination I should pass. I have a 10 years experience. I should pass the exam.
No, you are not supposed to.
Okay, so what is the limit?
So
See,
there are the various criteria. If you're falling in those
primarily,
criteria,
if you are a
you are
director
exempted.
of a listed entity for 3 years, you will be exempted from giving any examination. Proficiency test is not required.
Okay, in case of any independent director has not cleared the proficiency test, whether he is continue as independent director. First question. If some listed company, the secretarial auditor has qualified the report that position such direct is non-executive, non-independent director, is it right?
So now with the recent change, what we discussed, I think what Ankit was discussing. So even if you have not passed and 2 years had passed over, now you have an option that you make an application for restoration of your name in the database. Your name will be restored and your name will continue to appear there for next 1 year. In next 1 year, you have to pass the exam. I believe in that backdrop, there will not be any non-compliance on the part of the independent director.
Okay. Amit, when charge is created by lender with the knowledge of the borrower with MCA, is it a responsibility of the lender to file a form with information utility? And if so, within what time period?
So information utility is a separate requirement which comes under the Insolvency and Bankruptcy Code. So he has the obligation to file that information within 30 days from the date of giving of the loan. That is in addition to whatever he is doing for MCA under the Companies Act or whatever he is doing in respect of CERSAI registration in respect of securities on which he is creating the charge.
Okay.
So it is in addition.
Okay. How the synchronization between the registry under SARFAESI, that is CERSAI, and information utility be done? They both will be separate and will be registered separately or be integrated.
I think as per Amit, they both are separate. You need to file intimation both the places. So as of now, they are not synchronized.
And let me just clarify, there is a difference. When we are filing the information with the Ministry of Corporate Affairs in Form CSG 1, there you are filing the documents also. Your documents are registered. Whereas in case of information utility, it is only and only information. There is a set of questions which are there and the set of information that you are providing. And whenever default happens, you just have to intimate that default has happened. What are the terms on which the loan was given and what is the default? That's it. So you are not required to register any document in case of information utility.
Okay.
So there will never be any synchronization.
Okay. Am I to, somebody is asking, am I to understand that IP also will have panel of IP as per the discussion paper? Somebody want to...
There will be a panel of insolvency professional entities also. I think question is that today the panel of insolvency professional is published for respective adjudicating authority. Tomorrow similar panel will include the insolvency professional entities also, who will also have the AFA. that is authorization for assignment, and after that they will be eligible to be getting their name registered in the respective panel, and their name could be directly referred by the adjudicating authority for being appointed as a IRP or RP.
Okay, Ravi, very interesting question for you, which I'll give answer also. There are many provisions of various regulation of capital market. Hefty fines are imposed on the company and the erring officials of the company. Is there any one who have addressed the issue of poor investor who have invested their hard-earned money is taken for a ride and put into loss because of these non-compliances? Expert view, please. So the point is simple, that I have purchased some share on the basis of some non-compliance. You have put in penalty on the officers, and you have put in the money in the SEBI or government account. But what investor has got? Ravi, to you.
Yes. In fact, there is a panel of NSE, and there is a separate investor education protection fund at a stock exchange level as well as the level of SEBI, from where this disgorgement is being done to the investors. They are getting refunds up to the extent of 25 lakh rupees. So in Karvi, in the case of Karvi, we have seen that people are getting refunds from there. Now, that's a fundamental question, whether for all violations, for all penalties that are levied on companies, should there be corresponding disgorgement to the investors? Well, that's a bigger question. So far, there have not been such cases where, in case of technical penalties, these are distributed to investors. But yes, when the public money is lost or is embezzled due to any fraudulent activity, these measures are taken. And in fact, Karvi is a live example.
But I think the purpose of penalty is to create deterrence in the minds of the officers of the company or the company to comply with the law. However, whenever there is a direct correlation between the default and the loss to the investor, there can be disgorgement, and that class action suits are well prevalent worldwide. Indian law also allows this type of thing. So if they can prove that they have invested based on certain information, certain misinformation, then they can certainly go for class action suit, and there will be recovery and there will be distribution.
Absolutely. I am in complete agreement what Manoj has submitted. India is yet to test the fruits of class action suit. Though the law was enabled after Satyam fiasco, when the Companies Act 2013 was getting enacted. So rightly so, the class action suit provisions are there in the books of statute, but still they are to be tested on the forums where the reliefs are being granted. But I think the momentum has started, and the right kind of investors and peoples may move forward to form these associations for putting forward their claims before the adjudicating authority. I'm sure we'll be able to move in a direction to realize the class action suits remedy.
So thank you very much, Amit, Ankit, Ravi, and Manoj. You have covered whatever last month, whatever amendment has come, whatever amendments or some important case law have come, we have discussed, and the concept paper we have discussed. So this is the theme of our program, which we are doing and which we'll do every month now, first Friday of the month. And my request to all the participants that if you have any question related to this, or if you want to change any structure of this program, please tell us. We will make more development in the structure of the program. You have any question, you can send it to us so we can ask. So the point is, whatever law government is bringing out, they are thinking that they are coming out with completeness. But there are 7 economists, there are 8 opinions. So here also we have various experts. They bring out point in the points. So, but it is also right, sometimes you read something and you find some new point, and when you are complying something, then it should be 100% clarity. So we want to provide that clarity. Today we will share the CP Connect to all participants also, and my thanks to all participants as well as my 4 learned speaker for this. Friends, this journey will continue, as you are aware, and I just want to announce the next Friday's webinar, that is on succession planning through trust. As you are aware that family run business are most prevalent form of business in India, and 80% business in India is family run. And now what is the problem? The problem is that everybody wants that after his demise or after his tenure is over, then company should run properly. So they want to develop a structure for transition of wealth from generation to generation, ensure continuity of business, ensure tax efficient system, and avoid family dispute. So business should run properly. So whatever future dispute will come, whatever future problem will come, they want to cover up today. So we will discuss this issue, and the key area of discussion will be why succession planning through trust, transferring of listed
Yeah, होने वाला बस.
private trust, taxation impact by shifting the entire shareholding in private trust, because SAST law will applicable when you are transferring shares to. So SEBI has provided exemption with some rider. Benefit of forming trust in listed company. We will discuss all these points in the next webinar, which is 94th webinar of corporate professional. And I hope the large number people will come. It is a good for every business, everybody, and every family to understand this concept and understand the nuances of this. Thank you very much. Thank you for participation. Thank you very much.